Now, just coming to what we have now, the world we are in right now, ukiturn upande wa kulia ni mambo ya sheria, ukigeuka upande huu mwingine ni sheria, ukiangalia nyuma, ukienda mbele, at least you will find yourself in a place where you are struggling with the law. Now, that's more general, but to be on the point, we are in the world of litigations, and it's quite expensive. Is there a way people can access these services in a cheaper way? Is there a way, because in one way or another, you'll find yourself, interacting with the law and the lawyers and the judges and the magistrates and all that. Is there a way we can access these services for the very person who may not have that much money, 65 million?
Yes, I would like to direct that question to... Okay, all right. I've directed, we can take another question. We have like 3 questions and then we'll have them answer. Yes.
Thank you so much, Mr. Moderator and our facilitators. I am Pastor Michael Wanyama. I want to appreciate that the subject is really at home. It's something that is pinching all of us. I was reluctant to stand and just talk, but let me just say, because some what I may ask can help also others. One thing I want to say that I would not know, when we say that we have to prepare inheritance for our children. Some of the generation that we live in, many of our children, in as much as we try to educate them and make them follow us, but you find that many parents have failed in that way. We have not reached where our our facilitator is today. You find that many of them don't follow us 100% or even 20%. Let me say the Gen Z generation. You know what I'm talking about. So, if you fall in such a situation, you know that your children, if if I'm talking that I have a net worth of 10 million or 100 million, as it may be, you look at your children and then you say, can these people handle this? You know, let alone even that, even if I have 2 cows or 2 bulls, you know, you look at, can he handle this? Many of the children that will inherit things, they get it today and then they think of something else and they destroy it. So I think there should be some consideration. What should I consider? Even like I would have 4 sons or 5 sons. What would I consider to say this one should have? You know, in traditional ways, that the first son should have a bigger chunk and then the second one like that. But I don't think maybe that's the best way to divide your property. Another typical situation that I've encountered myself, where I was working some time ago, where somebody, a colleague of mine, almost my age, died, and then he had a will, not really a will, but those forms that we signed for succession, the nomination forms and all that, nominees. And then everything is signed 100% to his wife. His children were still very young. But we went and buried the person, coincidentally, when he was one of our members of Crisco, in the Crisco family. We went and buried the person in Migori. And then after burial, we came back. Then after some time, then we realized that the mother, who was at home there, our old widow now, was suffering so much. Nothing was left for her. And this wife stayed in Nairobi here, where they have done a house in Kitengela, and they were living comfortably. So you came to wonder now, is it my wife first or my mother first? You know, that question that often come. And then you don't know, you may say that, oh, is my, you know, that kind of situation that many people come into. I think we need to comment on that so that we know that though my wife and my children are important, what about my parents? Lastly, question of trustee, you have mentioned trustee. I think all of us live in Kenya, you will agree with me. The issue of getting money from trustees, especially government trustee, is so difficult and it takes ages. I know families who have followed up money for over 10 years until even the children who are supposed to be held by the money dies I mean not dies, but becomes of age. They have finished their schooling, the money has not come out. The parents now, if the widow was left, she has gone. What is the problem? What should we do so that even if the money goes to the trustee, you can get it? I must confess, I have 1 or 2 accounts. I hardly tell my wife everything that I do, because sometimes these wives that we have, you know them. They are very holy, but sometimes you know them. So I hardly, but you see, it happens that at one time you are not there. And then you realize money is there. But following that money, even with the laws that are already there, what advice would you give me, or would you give us, so that the money can come out? Or rather, is it the law? Where is the problem? Thank you.
Thank you so much for that. Maybe a third question. Then I give the panelists a chance. Yes, there's a hand there.
Yes, thank you for the wonderful discussion. So I'll go quickly into I have 2 questions. Number 1, my name is Jeremiah Omungala. I'm saved, persuaded of better things that accompany salvation. So just in case you confuse me with presbyter, hapo kwa M-Pesa kwanza ndio mzuri, si ndio? So mkituma tu hapa hiyo siwezi kataa, sivyo? Number 1, if we could get a definition of the word guardian ad litem, and in relation to succession. Number 2, in the case of somebody who's grown old, they've become, can I use the word senile? And they are unable to either do that will, or how do we carry out succession in that kind of a situation? Thank you.
Thank you so much for that. Wakili Lucas, you'll take the first question, and then will be followed by Wakili, and then Presbyter.
Okay. Bwana asifiwe. Bwana asifiwe tena. Kwa majina vile Presbyter alisema, naitwa Lucas Onyina. Nimeokoka, Kristo Yesu ni Bwana, na mimi ni mshirika wa kanisa hili. Sasa kuna maswali yameulizwa, na swali la kwanza lilikuwa la Presbyter, na amesononeka akisema ya kwamba gharama ya kufuatilia kesi hapa Kenya ni ya juu sana, na nauliza kunaweza fanywa jambo gani ili gharama iweze kupunguza kwa manufaa ya yeyote aliyehitaji huduma ya kisheria. Nitaongea kama mtu wakati huu amevaa kofia ya upande wa mahakama. Sisi kama mahakama hapa Kenya, kupitia kiongozi wetu ambaye ni Jaji Mkuu Martha Koome, tuko na ile taratibu ya kazi, ama ile kwa lugha ya Kimombo tunaita strategic plan, ambaye madhumuni yake ni social transformation through access to justice. So access to justice, sijui hiyo nitasema aje kwa Kiswahili. Access to justice is one of the key pillars, and we are focusing on making it very easy for every person in Kenya to be able to access our services, and therefore fees have been reduced downwards, and we are also embracing information and communications technology. I think now in Kenya we have the best ICT infrastructure, not even e-citizen. So now it is possible for anybody to access. You can file your case on your own, if you are able, from the comfort of your room, without having to consult anybody, and you can attend our courts from the comfort of your room without having to spend any cost on travel. So majorly now the cost of litigation is determined by how much your lawyer will charge. Because if you get a lawyer who will charge you a lot of money, it is your choice. And now in Kenya, we are spoiled for choices. We have lawyers all over. You can see here, 3 of us are readily available. If you walk around, you'll see law firms everywhere. In our courts, we handle so many students. I think this year alone, we have handled over 200, and more are coming next week, around 90. So Presbyter currently Kenya, and I can confidently say that Kenya, we don't appreciate ourselves. But Kenya, we are the best. We are on top of the world. Because we have countries even in Europe coming to benchmark with Kenya. And more will still be done to improve access to justice. The lawyers have what we call advocates remuneration order, which determines the minimum fee that can be charged for specified services within the order, so that we do not also have advocates undercutting, some charging below the scale, because we also focus on maintaining quality of the services being rendered, so that we don't have substandard services being rendered at cheaper cost. I was limited to answering only one question, and I think I've done justice to it. I'm being told to proceed. Many children do not follow their parents and are not prepared to manage what is bequeathed to them. Yes, we are all created differently. We have children, but they have minds of their own. But as I will call him pastor, as our legal pastor here said, train up a child the way he should go. And when the child grows up, he or she will not depart from it. And that is biblical. So we start from a very young age. Look at Abraham and Isaac. Isaac was able to manage everything that the father left behind. And the Bible says he was very rich. So we have 2 examples. We have Isaac and the others, and we also have the prodigal son, who was not prepared for his inheritance and ended up wasting everything. So timing, I think, is also very important, so that we prepare them, and if we are to hand over anything to them, we do it at the right time when we are sure that they are ready. The book of Proverbs, chapter 20, verse 21 says that an inheritance gotten in haste will not last. So even as you prepare to hand over, don't hand over when you are not sure that the person is ready to manage what he or she is being bequeathed to. And then I'll give an example of our Lord Jesus Christ. He started preparing his disciples for his absence very early. And as a parent, one day you will not be there. Are you preparing for your absence? Because, yes, a man shall die once, and after that, there's judgment. So you'll only die once. So the question is not whether, it's when, where, and how. So are you prepared? There was a preacher called Miles Munroe. Miles Munroe used to talk a lot about preparing, for his absence. And towards the end of his life, he was explaining how he had prepared his children to manage all his businesses. So he wasn't doing anything. His was to advise and be there as a consultant. I pray that God will help us, that we are also able to do such a thing before we leave the surface of this earth. Bwana asifiwe. Then how do you decide how much to give to who? The law says, I think it is section 3, subsection 5 of the Law of Succession Act, that every dependent should be reasonably provided for. What is reasonable would be determined by circumstances of each and every case, because there's no one shoe fit it all situation. And where a parent has not properly distributed property equitably to his or her dependents, even if it is in his own will, the courts have power to do redistribution. I hope I'm not dominating. Guardian ad litem, I'll leave it to my friend here to answer. How do you get money from trustees? I'm not sure I have a good answer for that. But to tackle a bit of it, you see, many of us, a number of us are in employment, and we have retirement benefit schemes, whether defined benefits or contributory schemes. So there are nomination of beneficiary forms that are normally filled. As you fill the forms, you are also allowed to distribute your property there, express your wish. But at the end of it all, the trustees, because these schemes and all schemes have trustees who run them. The trustees, the moment you die, they'll be able to assess and see whether you did distribute properly or not. Those who have shares in SACCOs, you fill forms, and upon death, the properties are distributed as per your wish. And these two are not subject to succession. I will leave the public trustee part for my colleagues to be able to answer. When a person is of unsound mind, he cannot make a will, because there are requirements for a valid will that are specified in the law. I think if you read, is it section 8, 9 of the Law of Succession Act, you must be of sound mind so that you are able to express your will. And therefore, if a person is not of sound mind and he happens to pass away without being able to write a will, even if he's of sound mind and has not left a will, then I heard my brother talk of intestate succession. Yeah, there are different forms for testate and intestate succession. And these forms are easily accessible. If it is testate succession, then we have forms. There's PA 80, that is a petition for grant of letters of administration intestate. We have affidavit of support in support of the petition. We have a document that is filed by guarantors. So we have P&A 11, P&A 80, P&A 12. So they are filled and submitted. And these ones you can do in person. Thank you. I'll let my co-panelists continue. Thank you.
Thank you so much. Let us appreciate him. Are we learning? Wonderful, wonderful. Subsection C? Article? We are learning, we are learning, we are learning. Thank you so much.
Thank you, thank you. I'll talk about inheritance. because it's a pet subject. I love talking about parenting and who do you live what with, how, and as Honorable Onyina says here, these things must start from very far. You cannot start it when your children are old, right? But I want to be a bit practical here. I have practiced law of succession for over 25 years. Acted for the high and mighty in this land. And I have a conviction myself that wealth that is ill-gotten inapotelea. Right? A lot of these men stole from the public to create wealth, left widows in tears, and a lot of people in tears, or even killed. And my conviction, without naming names, this wealth never helps the future generation. Men of purpose, ill-gotten wealth can never benefit future generations. I'm not bragging, but by any standards, God has blessed me. Na repeat, mimi ni mjama wa mtaa, mimi ni mjama wa Kibich. But God has blessed me by any standards. And I can stand and say that it is the grace and the favor and the mercies of God. And I have a conviction the generations after me will enjoy, because it's not ill-gotten wealth. So as you struggle in days, whatever you do, usipimie mtu skari umbakisha kidogo, will make more money. That will never help. And that's the conviction I have. I own assets. If you come to a property of mine and you want to put a bar, even if you're paying me 6 times more than normal, I will not accept. I don't want a dirty money. Because if I promote alcohol, what will happen to future generations? So, as Christians, men of purpose, we must, and my children know that daddy doesn't tolerate this. My children know that if you come, the other day I'm selling a property for some clients of mine and I'm managing the entire process. Some gentlemen came and they said, we want to buy. It's in Karen, but we are buying 3 of them. And in one we want to put a mosque. I said, no, I didn't care about the money. I'm a Christian. I'm very clear in my mind of my principles. So as we make wealth, let's fuata laini ya Yesu Kristo. Number 2, train our children from very young. Now, if we missed the gap and we realize they've grown a bit older, na tunaona wameanza kuenda hivi, drop everything and play your role as a man, even if it means taking your children for counseling or to seek professional help. That is the purpose of a man. You don't see things dropping and you look the other way around. Let's help our children slowly. Next, let's start getting confidence in our children. I am a father of an adult child, 2 Gen Z na kadogo. And I know hata wakubwa, in our mind tunaonanga tu ni watoto. In our mind we think they can't do, right? But I can tell you, the other day I wanted an architect and I wanted to start another project. And what did I do? When the architect came for a meeting, I called 2 of my children to sit in the meeting. And the architect anatuambia hii tunatafanya hii, alafu nauza kijana wangu watoto wangu, what do you think? Is there a proposal you think? Go think about it. Right? And that project, that land, it is my son who got it. And told me, Daddy, hey, this land is a good deal. Let's buy it. It's because I had started training him when he was young. Let's fuata Yesu, this narrow way, and start early. And if we've lost the gap, let's be men enough and play our role. Warudisha laini. Now, he talked about sharing. Just be, it can't be exactly the same. Equitable. What do you think is equitable? Talk about trustees. Section 66 talks about the preference of law succession of who can file a matter in court for probate. And the first preference is the spouse, then the beneficiaries who are children, the like. Then it comes to public trustee. That is when amwezi kusikizana how to manage assets, what to do, right? Now, don't in your family allow matter to go to the public trustee. Always try and agree amongst the families. I am aware at times we come from polygamous families. There are many fights, and my view has always been, it doesn't matter which area, which village comes from. There is 1 or 2 people with gray hair, kama baba yetu hapa, ama wachungaji, wanaweza itwa kwa hiyo mkutano na wawakalishe nyinyi wote chini and help you get a decision. Don't, even if you think your siblings or your people are very unreasonable, right? Sisi ni Wakristo above everything else, right? Look the other way, call somebody to mediate so that you don't get to the point where assets are family. Then you end up through the public trustee. Agree if you can't get a third person to assist, right? A pastor, a bishop, or even a village elder. And there are those who can be able to help you sit and resolve issues. Adrian ad litem wanauliza kama wakili. Kwa lugha rahisi hii kimombo kizungu mingi ni kusema mtu ameappointiwa ni koti akuja ashikilie. Right? What does that mean? We have an act called Mental Health Act, where you find somebody has a challenge, right? A medical challenge, all right? Or I have been in the medical sector for about 15 years, so I know a bit of medicine. I've been a consultant in the medical council for many years. And what I know is that when men get to the age of 70, 75, and start going up beyond there, there's something called cerebral atrophy in medicine. The brain starts to reduce and shrink. I don't know why it is men, I've never known, but it's medicine. For women, inaenda at 80, 90 wako sawa. And that's why you find it's a medical issue and it comes with age. What presbyter sijui is kina Methuselah wakifika 900, what used to happen? Because Methuselah got Lamech at 165 years old, right? And Lamech then begotten Noah. And at our age, mzee akifika 50 kazi zingine, vitu zina change, 60. All right, so those are things, so Deuteronomy 26:26, right? But the brain starts to shrink, it's a medical factor. Unakuta mzee anasahau, then with time anapata dementia. It's a medical issue. So what does the Mental Health Act provides? It provides that somebody can be appointed as a guardian, 1 or 2 family members to step into the shoes of that person. Ndio hiyo kizungu mingi imetoka ya guardian ad litem. And then there is also the instance of children under the Children Act, all right, where children cannot make decisions because they are minors. And that's why if you look at the Children's Act, to provide for appointment of guardians to stand in the shoes of the person. Asante.
Thank you so much. Let us appreciate Wakili. Okay. Briefly, let's listen to counsel. Karibu sana.
Praise the Lord. It is good to speak last because they have said all the important things. So if you were in court, I would have just said I have nothing useful to add. But let me add something small. One, representation. Our brother, Honorable Onyena, gave the judicial side. On this other side, if you cannot afford a lawyer's fee in court, the law also allows you. You can apply to court, and then the court can listen to you. If you are to file some documents and you are unable to because you don't have money, the court can order that you file them without paying any cent. Secondly, we have in law what is called pauper briefs. Pauper briefs basically means that you get legal representation for free. I know as a lawyer, when I feel every year when you go for practicing certificate and you say your area of practice, one of them down there I write pauper briefs, or maybe 10% or 15%. So it is also, you should not fear walking into Peter's office or my office and just say, I know I cannot afford your fee, but I'm asking that if it is possible, you represent me for free. We are allowed by law. What we are not allowed to do is to charge you less. It is called undercutting. It is an offense in our profession. We are the only profession where you have the minimum fee and not the maximum. So no client can take you to court that so-and-so charged me only $1 million for this. Why are you charging me 10 million? No, I'm allowed to charge you 100 million. But I should not charge you below 1 million if that is the lowest. So there's that aspect of pauper brief. If we get it well, you can go to an advocate, you can request that they just do your case for free. I want to mention something also on the distribution. The word is equitable, and that has clearly been stated. But I will only add one small bit, that you cannot disinherit any of the beneficiaries. There we read some strange things in those other parts of the world where somebody has given his whole property to a dog or to a cat, loved the cat so much that left the wife and the children and gave the whole property to a cat. Or a situation where, as a father, I'm not agreeing with one of my children and I say, "We utaniona." So in your will, you write and you say, child A gets 0. And the rest of them get the others. The court will step in and they will interfere with that kind of a will because you are not allowed to disinherit. But the court is not tying your hands. I would say, my own thinking, that if it were possible, give your children equal shares. Because again, you will have created, if you don't do that, you will create animosity in your family. They'll say, "Our father, why were you given so much and I was given so little?" If you can distribute equally, that for me would be the best. But again, the property belongs to you and you are the one with the knife. So if one anakusumbuaga sana, unaweza kumkatia tu, you don't disinherit him, but somebody who might get more than the other. So that is the other issue I wanted to state. The other thing, somebody asked about this lady who goes, buries the husband, everything in her name, and she comes back. What I know the law talks about is, if this lady marries another person, then she will cede the right to some of the things that she received. But really, this is your family. The others are tier 2 and tier 3, as it goes. Where I come from, everybody is a brother and a sister. And sometimes they will really know how to misuse, quote unquote, the property that you have. They would many times want to disinherit your spouse. If it is the man who dies first, the spouse would be disinherited. So we must be careful, and I think that is why it is important to have a will, so that your spouse is properly taken care of. And many times I also advise that if you can buy property in joint names, something else, if we went to land laws and all, joint ownership and ownership in common, one would apply where when you die, you don't need to, your wife would not go for succession to continue. each one of you owns the whole of it, and yet both of you owns the whole of it. And another one, you have distinct share, where it's maybe 50-50, 40-60, whichever way you've agreed. And that would mean that if it is 50-50, if your spouse dies, then you must do succession to the extent of the 50 that she was holding or that he was holding. So that is it. Just rushing. And then I think the last issue I wanted to mention, and which has been said, is that a senile person, one, cannot do a will, and two, if it is intestate, as our brother said, again, just a word to mean that you died without writing a will or giving out a will. So lawyers love those mouth-filling words. So if a person is senile, whether you are senile or not senile, if a madman dies and he had properties, and if a sane man died and he had properties and there was no will, they are the same. The process is the same. So I hope we have managed to answer a few of the questions. Maybe we could take another round, and we are mindful of time also, so that we move to the next session.
Thank you so much. Let us appreciate Presbyter. Well, we have some wonderful questions here streaming, and I'm going to allow Mrs. Jackson here to take us through some of the questions. These are going to be quick fire, so you just take a minute, answer, and then go to the next person like that.
Praise the Lord. Thank you for this opportunity. So right to our first question. How do I handle a situation with my 37-year-old son out of wedlock who called me to demand for his inheritance? I'm still alive, sija kufa.
Yes, thank you. Sounds like Luke 15. Inheritance is upon demise or upon death. As long as your parent is alive, you have no right to claim your inheritance. You can start working for your own.
Thank you very much. Thank you very much. And to our next question. In the event a parent or a guardian does not disclose assets, to be specific like land, to the wife or children, is there a platform one can check, for example, UFAA for unclaimed assets or unclaimed financial assets?
I think unclaimed financial assets, you can claim for bank account, you can check for bank accounts, you can check for shares, you can check for such. But when it comes to maguta plots, it becomes a bit challenging. And that is why you find a lot of people are losing property. And that's the main reason I'm saying, for us Christians, disclose, and not only disclose, mpeleke umuoneshe ndio hii plot.
Thank you very much.
I don't think there's anybody you love who you cannot tell your secrets. Your wife has seen you without clothes. So what is it you're hiding from her? So just let people know what you have, so that for safety of everyone. Thank you.
Thank you very much. At what age should a parent pass over the inheritance to the sons and daughters? At what point should someone write a will? What happens to those parents who do not want to give inheritance to their children?
Okay, at what age should
at what age should a parent pass over the inheritance to the sons and daughters?
All right, I join issues and then agree with my brother Lucas. He says work for yours. Because when you say at what point, it presupposes that the father is still alive. That is why they want you to pass. Once you are an adult, you are on your own. 18, look for your wealth. Your father looked for his and continue. So there's no law that compels you that you must, in your lifetime, give property to your children, unless probably ancestral land that you are not supposed to sell, you are holding in trust. But what you worked for, self-acquired property, that is your property. If you insist that you give him and you wanted to sell it to go to Hawaii, then what would happen to your trip to Hawaii? So there's no age limit when you are supposed to give. But again, it comes to what our brother Peter was saying. When you train your children and they know and there is transparency, one of the things that the children will know, and I think that is where we have failed in as parents many times, we make our children believe that our wealth is ours and they are not part of it. But the moment we train our children and bring them up in a way that they feel that you are also just holding it, but really it is ours as in the whole family, they won't have a problem. And when we train our children, it becomes very good. There was something about will. At what
point should you write a will?
A will, the point of writing a will is now. This is the time to write a will.
Okay.
Why? Because at least we are sure we are alive now. We don't know what is going to happen in the next minute. So I would say that will should be as written as early as now.
Okay, thank you.
And then just to add on to what Presbyter said, there are two types of wills. That one is asking about written will. If it is an oral will, then not more than 3 months before you die.
Okay, thank you. What happens to those parents who do not want to give you inheritance in case they say that they were not also given the inheritance?
I think I've answered that, didn't I? I said every child look for your wealth. You can't go demanding for wealth from your father.
Okay.
Look for your wealth. But if you are very evil and your father is very rich, pray that he dies, because then you will not have any control.
Okay, thank you. About the will, should your spouse be privy or know your will? Number 2, about the will, what is the procedure of writing a valid will? Then can you change the will after you declare it?
Now, I rushed through the clip. I had talked about a will. Wills are changed, right? And as you grow with age, you get more children. You create, by the grace of God, more wealth. Circumstances change, right? So with time, you keep changing the will. I here changed my will 2 weeks ago because my wife rested the other day and I had left most of the stuff for her to control. I had circumstances that changed. So you have to change with circumstances. I have a friend who adopted a daughter, bright daughter, and I had done his will. So you don't want to leave her out. So wills can be changed at any time. Privy, ordinarily wills are done in private. You create a will, you prepare. You must sign in the presence of 2 witnesses. So when they are signing, you have 2 witnesses who comes and says, yes, we have seen him sign. The purpose is to say, yes, we have seen him sign, but not to know the contents. But it's not wrong for your wife to be present. I have done wills for some old man of mine who had a lot of wealth, and as I drafted it, he came with his wife. He says, everything I have, my wife knows. I have no other child. And we sat, and the wife's ready to say, "Apana hii toa yu pekee huyu and they agreed. And he signed, but the wife was not a witness. Other people, 2 witnesses were there, and they saw. So there's nothing that prohibits that your wife has seen it. But the witnesses were different because she is a beneficiary of that will.
Thank you.
To add, a written will can be altered only in writing by what is called a codicil of a will. There's a trend where, say, for example, somebody had a written will, and then now he goes and changes it orally, and then as he's doing so, is recorded. There's a video recording. That recording should be reduced into writing, otherwise it will not serve any purpose of changing the will.
Thank you.
I think I need to add one more. You just mentioned a codicil, and I thought it's important I also disclose. There are times you leave, a codicil is like something in addition to, right? And at times you do what we call a burial instructions, right? Where you don't want your will to be read before your burial. But there's a specific way you want burial done, right? So you create that document, and hiyo kizungu mingi, codicil. Okay, ama burial instructions, you say, persons to this will of dated this, my burial should be this. And this happens a lot from UK or some other places where there's a trend. Presbyter, I don't want to talk about it because I don't agree with it, but there's a trend right now of people wanting to do cremation. Right? You've seen it? And so they have a will, and then they create a codicil. And I've seen it right now. I don't know whether it's the thing or wamesoma sana, I don't know. Where they say, this, I want to be burned, or my body to go for science. Right? And there's even litigation about it. And the court has held it is his will, and the court upholds his will. And then he creates a document, a codicil, where he says, this one should be open before burial, which is the burial instructions, how I want it done. And then the other will is the other one.
Thank you very much. The problem of telling the wife everything in the bank account is that there's a tendency of wasting the money. So they want to squander the money until everything, nothing's left. What can I do?
That's an opinion, really. That's an opinion. But if you love your wife, right? I thought it is us men who squander the money. And from where I sit, and women wanajaribu kutuweka pamoja. But I think that's a topic for another day with Presbyter. But I think your wife should be your friend. Your wife must be your friend. Your wife must be somebody you sit and agree. I earn this much. My business makes this much. I think we leave this much for investment. We do this. And that way, you can never have secrets against one another or mistrust. Because you're sleeping together. Are you saying your wife atachukua kisu ukiwa umelala? Because this is your friend. So that should never happen for any Christian man. And if you have that thought, jite mkutano, then from there, take your wife out for a drink, for coffee. Take her out, get back to the first love. Asante.
Thank you. Can a man entrust his succession to only his spouse and children, or also his parents?
You said, can a man
entrust his inheritance to children or spouse only, or also had parents?
I presume that is about a will. Eh? Who can you give property to? You can give property to whoever you want. Okay. You can even give property to your pastor. You can give property to myself. It's your discretion. Because it is your property, you decide what to do with it. So you can give it to anybody you want to. I hope we are coming to the tail end, because...
How can I distribute my wealth between my wives, in case I have more than one? And then children, is it equal, in case I do not have a will?
Yes, again, I think we touched on it. Distribution is very discretionary. The only check is that you do not disinherit. I think that is what the law would come heavily against. And again, you should not be outrightly biased. There really must be justification. If you have 100 million in your account and you are giving one 1 million and the other one 99 million, there really must be a good reason why. Though you have given something, but it is not, there should be an explanation as to why. So for a person who has more than one wife, it's upon you now to distribute. I don't know whether it's according to love, or but I know for Christians, it is between one man and one woman. That is what we say. So, but that is also a reality, that not everybody is a Christian, and their families, like our good brother told us, the father had how many? Was it 10? The wives? Yeah? 16 wives. So, if he didn't kama kufanya kazi ashike shamba kubwa, ole wake.
Okay. How can I deal with the tax exposure to family property? How can I minimize?
Tax exposure. Now, when you are doing, after a deceased person goes and assets are distributed, right? What happens is, after that, we call it in law transmission. The transfer is called a transmission. You don't pay the ordinary stamp duty of 4%. It's minimal. It's minimal, very minimal. So that when it comes to transmissions, there's no the normal 4%, the normal 2%. It's not there. So there is no exposure after passing on of a person, right? Now the other issue of tax exposures in business, I think that's a topic for another day, right? When we talk about finances, there's one thing she's asked about a mother and the wife. I think it's a common war at home, or not war ya vita, but ile dome. You get what I'm saying? And I have 10 principles of success, and they're all biblical principles. And one of them is about your parent. You cannot afford to be driving and living a good life, and your parents live a terrible life in the village. Never. And there are scriptures about it, but it's not a topic for today. And there are 10 principles. That's one of my principles of success in life. Now, as a man, we have wisdom and we have God on our sides. And it's upon us to balance that act, to ensure your wife and your children live a comfortable life, but also to ensure your parents don't suffer in the villages. And I tell young people, and I tell people who start working and wanapeleka masubaru, it only takes you to have a number of a boda boda and the number of a supermarket in the village. You pay the supermarket, unamwambia drop kwa mama yangu. You cannot afford to live well in Nairobi, and your life is suffering. Thank you.
Asante. My great-grandfather died without ownership of a piece of land. My grandfather too, and my father also died without an ownership of the very land. Now where and how can I get help of ownership so that I can leave lawful succession to my children?
So if there was no title, right, in the lands office, that title must have a number. Title number da da da. Land reference number da 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 da. You get it? All you need is get that reference number, right? Even without a lawyer, you walk to the land registry of that area, and they can assist you to get the registration. If it's registered in your great-grandfather or your grandfather's name, and there was no probate, ama hawakuenda kufanya succession, it's a process that you'll be guided, and it can be done, and the title can be obtained.
Thank you.
Just to add, thank you. Every land that has a title number has an owner. So if you have the number, go and conduct a search, and then you'll be able to confirm whether it is in the name of your great-grandfather or grandfather or your father. You could be saying that they did not have the physical land title document. Once you get to know in whose name it is, then you can be able to follow up and be able to obtain one. Thank you.
Thank you. If you started a business with a spouse, then you notice that she registered the business alone, what do you do in terms of succession?
Oh, business with a spouse. And you remember, Pastor Mongala, you need a talk on marital issues, right? Because you have, and this, when I talk many places, you find kuna plot ilinunuliwa secrets na hakuna mtu anajua. Kuna mtu anafanya hii na hakuna mtu anajua. My issue is, why did you marry that lady you live with? It's because you loved her. And so I believe it's because you still love her. Sio juu ya watoto. Watoto wamewapata na wataenda. And when I can tell you, I lost a friend. My wife was my friend. My children, hata leo, can never tell you they've ever seen me argue with their children, with their mother. Because she was my friend. Hakukuwa siri. Now, what am I talking to men of purpose? You must commit to have your wife to be your best friend. Watoto wataenda shule, watawacha. And once she's your friend, there is no secrecy. And when there's an issue like that, men of purpose never shout at their wives or hit their women. You sit and talk. This company, this has happened. We are one. How do we deal with this issue? And address it at home and resolve. Mkilemewa, Presbyter Mungala na Timothy wako hapa. Asante.
Asante. At what point is the Constitution relieving parents of responsibility to take care of their children? Then the next one, in case of a divorce, who has the obligation to take care of the children? And then lastly, how can you give inheritance to our young children, 5 to 10 years, by the law so that they're protected and not chased away after one passes on?
Right. Number one, when assets are left to the children, the court gives an order. And the court yuko hapa. Oni mtu mkubwa hata ukimwona hapa. They give an order appointing this person. If it's an finances in account, you find there's an order they issue that this account be held in court on behalf of these minors until they reach the age of majority. That is the age of 18. And anytime you want, you go back to them because they are there to ensure nothing happens, right? Or the man or the other side does not marry and squanders and children are left to it. And if their assets, you find they are registered in somebody and they go back to the term used to hold in trust for those children. So there's a process of ensuring that the children are protected, right? Was there a question, another question?
How long does it take in Kenya for traffic case to end and families to be compensated?
Okay, mimi msifanyi hiyo traffic, hawa ndio experts.
Sorry, the previous question was also talking about protection of children by the Constitution. If you read Article 53, sub-article 2 of the Constitution, it talks about best interest of the child. And then we have the Children Act, Section 8 talks of the same thing. And we have rules under the Children Act, which now specify, they give they expound on what the phrase best interest of the child means. Traffic cases, they don't take long. As such, those are petty cases. If you plead guilty, they'll end on the same day. If you plead not guilty, then they go through the normal trial process, the length of which is determined by a number of variables, including your readiness to proceed with the case when you come. Presbyter wanted to add something.
Yes, I think covered pretty well. There's that guardian ad litem that we were talking about. The court would appoint a guardian ad litem for property of children that are young, so that other than the other orders that the court would give. We are also digressing a bit in our questioning because now traffic cases has nothing to do with taxation. Yes, and time, we want to manage our time. We want to see the last question, and then a mic would be passed over to Pastor. He had requested he had something to ask, and then we want to call it a day, if you allowed us.
Okay. So give a comment on the impact of religious organization, Bill 2024, on church management and succession planning. Because men are the head of the church.
First, we need to have a look at that bill before then we can comprehensively respond. But I know there is a bill that as church, all of us, we need to take an interest in knowing what it talks about. I must say, I don't know if my co-panelists have had a chance to go through the bill, but I've just seen it, I've not gone through it. So I would be very limited in commenting on what is in there. But I just want to make this sweeping statement that as church, let us take keen interest on that bill, because there are many things. I would say this with a tongue in the cheek. I wonder why my money as a Christian should be paying Kadis who are dealing with their issues. And the law says they will be dealing with their own issues, Muslim issues. I'm not a Muslim. So why should I pay for a Kadi? We slept on the job when that constitution was being passed, and we let the Kadis court in and all that. It's good to pray, but it's good to we watch and pray. So we look at some of these things. If Pastor would get the microphone, and so that we quickly wrap this, and then we can move on, because we are really eaten into our time.
Asante Presbyter Okello. Nina maswali mawili. Kwanza, kwa majina naitwa Pastor Filipo na hudumu na kanisa letu la Kajiado pale mjini. Na swali langu la kwanza ni, wakati umeandika will na ukagawa mali yako vizuri, lakini bahati mbaya yule watoto wako wote hakuna yule ameoa, ama wengine wameoa, wengine hawajaoa, na wengine wameolewa, wengine hawajaolewa. Alafu kwa bahati mbaya yule hajaolewa ama hajaoa akafa, wakati mzee akafa na yule mtoto akafa, ukoja badilisha ile mali itaenda kwa nani? Swali yangu ni, je, hiyo mali ambao ya huyu mtoto ambaye alikuwa hana mke ama hana mume itaenda kwa nani kama mzee atakuwa amekufa na yule mtoto amekufa? Swali la pili ndalichorea mchoro kwanza ndio nilete swali. Kwa sasa tunaishi kwenye dunia ya watu wanaopenda mali. Kwa mfano, umeoa na mkatafuta mali na mke wako, alafu kwa bahati mbaya mke akaja akaondoka, mzee akabaki, na uko na mali nyingi ambayo ndiyo inavutia wanawake wengi kuja kwako. Sasa kuna sheria katika nchi yetu ya Kenya inayosema unapokuja tena kuoa mke mwingine, akija katika anga lako, kwa maana uwezi ukajua kama ameletwa na mali ama kweli ni kuoa. Kama ameletwa na ile mali, kuna sheria inaweza ikasema, ama kuna sheria katika nchi yetu inasema mali ambapo mmekutania mwanzie na yeye hapo, lakini mali aliyekukutana naye hausiki, inahusu wewe watoto wako. Lakini pia na ile umemkuta naye, kwa maana huenda ikawa naye pia na watoto, ile naye umemkuta naye hausiki, kumaanisha yale ambao mmeanza naye leo, hayo ndio atakaye kuwa na yahusika wakati basi utakuwa umeondoka. Kuna sheria na namba ngapi na inaitwaje?
Asante.
Yes, ingawa ilikuwa Kiswahili lakini nitajibu kwa Kiingereza. Just a bit of it, and then my colleagues will also chip in. You are talking of when you've written a will and somebody dies, your child or son or daughter who is not married dies before you're now asking what happens to the property. Now, property can only be given to a person who is living. I'm assuming now that time you are dead. Let me start from that side. So you had property, you had 10 children, 4 of them died before when they were young, 6 are remaining. The distribution will be on the remaining ones, not on the dead ones, because who do you give to? They don't have anybody. But if somebody one of them died after marriage and they have a family, then that family must be taken care of in the distribution. So for a person who died, didn't have a wife, didn't have a child, there is nowhere where that property goes to. But for the one who has a family, even though he was the one who was your son, so you have your daughter-in-law and the children, they have an entitlement under the will, under the succession. But the other side is this. If your child dies and you have done a will, even if you had given that child property, and now he doesn't have a wife, she is not married, and she's dead, that is now where the amendment of the will kicks in. And our brother here is giving us a sad experience as it is, but he had to amend his will because the wife that was named and properties given to is now deceased. So no property goes to a deceased person. So that is why there's provision in law of amendment. So you can amend, if you are still alive and it is them who have died and you had given them some property in a will, amend that will and now remove them or give that property to somebody else who is alive. You continue.
Thank you. I think I need to clarify before I answer. I kept talking about my favorite, one of my favorite verses. It's Deuteronomy. I mentioned 26, it's 29, 29. Right? And it says, secret things belong to the Lord our God, but those which are revealed belong to us and our children. Okay, I love that scripture. I've just remembered that I said 26, 29, 29. Now, Pastor, umeuliza kuhusu will imefanywa na mtu mmoja anaaga na tuacha. Section 39 of the slow succession provides that when somebody dies, before they take a benefit of what was provided, it then says this is a priority of what should happen to that. And it says the father, the mother, the brothers, and the like. So the bloodline. I am aware that the other day FIDA went to court to challenge that because it says father then mother. Okay, and it says no, why father then mother? And they succeeded in court, but tentatively the law is it devolves ama inaenda kwa relatives wake. It doesn't hang in the air. It goes back, it left to Mr. Joroge or Kamau or Otieno is not there. He has no family, he has no children. Then it devolves to the rest of the family members in that priority as provided in law, right? And so there's no opportunity for a vacuum at all. What if somebody, let me rechange that question, dies, has no wife, has no children, but has a lot of assets and has no will? What happens to his assets? Right? There's what kicks in the public trustees, but also the blood relatives. That priority can move to court, right, to manage the assets of their sibling. Asante.
Thank you so much.
The second part of the question. The second part, I got it to be very personal, where you are asking whoever now might come. The relationship with vis-a-vis the property that the widower has already acquired. I don't want to give an outright answer to this, other than to say that there's a law that deals with all that. We call it Matrimonial Properties Act. At your own time, go and read sections 3, 4, and 5. and you find the answer for yourself. Thank you.
Thank you so much. Let us appreciate them. Are you blessed? Well, this comes to the end of our session today. And thank you so much, senior counsels, for the wonderful advice and counsel. God bless you. And from myself and Pauline, we say thank you so much. And we say men's conference court is adjourned. God bless.